Another important landmark judgment delivered by the Supreme Court was relating to the issues relating to reservation and protective discrimination, which affecting the provisions under Article 14, Article 15, and Article 16 of the Constitution of India, and that is Indra Sawhney vs. Union of India. So, the Supreme Court judgments in Indra Sawhney vs. Union of India in the year 1992 is a watershed movement in the India's legal and constitutional history. It reaffirmed the legitimacy of caste-based reservations as provided under Article 16, Clause 4 of the Constitution, while laying down crucial limitations such as the 50% cap and exclusion of the criminal law. The decision has since become the cornerstone for debate surrounding affirmative action, equality, and social justice in India. This case evolved around the interpretation of Article 16, Clause 4 of the Constitution of India, which empowers the state to make special provisions for the advancement of backward classes of citizens. The court scrutinized the validity of his memorandum issued by the Union government, which sought to implement the Mandal Commission report granting 27% reservation in public employment to socially and educationally backward classes. The case involved fundamental concepts such as reasonable classification, protective discrimination, creamy layer exclusion, judicial review, horizontal and vertical reservation, and the very basic structure doctrine evolved in the important leading case Keshavananda Bharati vs. State of Kerala in 1973. So, in particularly in this landmark judgment of Indra Sawhney vs. Union of India in 1992, the Supreme Court examined the constitutional validity of the government's decision to implement the Mandal Commission recommendations. In 1990, of his memorandum issued by the Union government extended 20% reservation to other backward classes in public employment. This decision sparked nationwide protest, debates, and legal challenges. The petitioners contended that such reservation violated the principle of equality as enshrined under Articles 14, 15, and 16 of the Constitution. The court, in detail and comprehensive judgment, upheld the government's power to reserve seats for backward classes under Article 16, Clause 4, but imposed essential such as reservation cannot exceed 50% except in extraordinary circumstances. The creamy layer must be excluded from the benefits of reservation. Economic criteria alone cannot be the sole basis for identifying backwardness. Reservations in promotions are not constitutionally permissible as under the very provisions of Article 16, Clause 4. This judgment is a critical landmark in balancing the very goals of affirmative actions with the principles of equality of opportunity, shaping the contours of reservation policies in India. So, while delivering this judgment, the Supreme Court refers certain important landmark judgments such as M.R. Balaji vs. State of Mysore, a judgment delivered by the Supreme Court in 1963, where it was held that caste cannot be the sole criterion for determining backwardness and that the extent of reservation should not exceed 50%. This case laid the groundwork for the 50% limit discussed in particularly in the present important leading case, that Indra Sawhney vs. Union of India, and in this next important leading case, as decided in the year 1976 in the judgment of State of Kerala vs. N.M. Thomas, a seven-judge bench accepted the view that reservation in promotion were valid, making a temporary shift in the court's understanding. However, in this present case, it is explicitly overruled this position. And another important ruling of the apex court in the year 1981 was made reference as Akhil Bharatiya Soshit Karmachari Sangha vs. Union of India, and in that particular case the court upheld reservations in promotions, which was again reviewed and reversed in the present important judgment, that is Indra Sawhney vs. Union of India. So, now we would like to analyze the very principles laid down in Indra Sawhney, as it was held that social backwardness must be rooted in caste and historical disadvantages, not just economic indicators. So, if we analyze in detail, making a critical assessment from the very beginning of this judgment, as it rooted, the Mandal Commission was headed by the then ex-Chief Minister of Bihar, Vindeshwari Prasad Mandal, was appointed in 1979 to identify socially and educationally backward classes and recommended measures for their advancement. So, in the year 1980, it submitted its reports suggesting a 27% reservation for other backward classes in addition to the existing 22.5% for the scheduled caste and scheduled tribes. After a political hiatus, the recommendations were implemented in 1990 by the then Prime Minister B.P. Singh's government. This led to massive civil unrest, self-immolations by students, and legal petitions challenging the validity of the implementation of the recommendations of the Mandal Commission report. So the very issues those come before the apex court relating to whether Article 16 Clause 4 is an exception to Article 16 Clause 1 or an extension of it. Secondly, whether caste can be used as a criterion to identify backward classes. Further, whether the 27% reservation violated the 50% ceiling. The next issue came before the court, whether reservation in promotions was constitutionally valid. Further, another issue raised in the judgment, whether the concept of the creamy layer should apply to other backward classes. So the very judgment, the court clarified that Article 16 Clause 4 is not an exception to Article 16 Clause 1, but rather a facet of equality. It facilitates substantive equality by enabling affirmative action. Further, the court ruled that caste can be a valid criterion for identifying backwardness among Hindus, but should not be the sole test. Socio-educational and economic conditions must also be evaluated. The judgment reinforced the 50% limit on reservation as a general rule drawn from, as already we have discussed about M.R. Balaji and versus State of Bihar judgment. However, it allowed for extraordinary circumstances such as geographical isolation or extreme backwardness to breach this limit. Further, a major contribution of this judgment was the introduction of the concept of creamy layer exclusion, disqualifying the advanced members of the other backward classes from reservation benefits. The objective was to ensure that benefits reach the truly disadvantaged sections. Further, the court held that economic backwardness alone does not qualify for reservation under, as provided Article 16, Clause 4. Social and educational backwardness must accompany economic disadvantage. The judgment struck down reservation in promotion as under Article 16, Clause 4, emphasizing that initial appointments may be reserved, but seniority and promotion must be based on merit and performance. This position was later partially reversed through an amendment, and that amendment was the 77th Constitutional Amendment Act, which added Article 16, Clause 4A. Lastly, the court asserted that identification of backward classes is subject to judicial review to avoid arbitrary inclusions. It recommended the creation of a permanent statutory commission, which was later on formed and inserted to the Constitution of India, which is at present known as the National Commission for Backward Classes, to evaluate and revise backward class list. And now we would like to analyze the very impact left after this judgment delivered in Indra Sawhney case, which had profound implications for Indian polity, administration and society. It led to the institutionalization of the criminal law doctrine, influencing every subsequent policy and judicial scrutiny of reservations. The verdict also struck a delicate balance between meritocracy and social justice, validating affirmative action while preventing its misuse. And following the judgment, such impacts as the central and state governments revised their other backward class lists, the reservation policies began incorporating creamy layer test. The Parliament passed the 77 constitutional amendments to allow reservation in promotion by inserting Article 16 Clause 4 and Article 16 Clause 4b. The case continues to serve as the legal compass for affirmative action discourse. And now we would like to conclude this very important landmark judgment of 1992, and that is Indra Sawhney vs. Union of India. The Indra Sawhney case stands as a landmark ruling that not only redefined reservation jurisprudence in India, but also catalyzed a national conversation on social justice, representation, and equality by validating caste as a key metric for affirmative action while cautioning against its excesses. The court tried to harmonize the very principle of formal equality with the need for real substantive equality. It remains a constitutional legal milestone and is frequently cited in both academic and political debates in India. As India continues to grapple with the issues of caste, class, and social equality, the principles laid down in Indra Sawhney judgment remain more relevant than ever. So, by this we conclude our lecture on one of the most landmark judgments delivered by the apex court in the year 1992 relating to protective discrimination, reservation to socially, economically, educationally backward classes.